The preamble to the Constitution reflects the commitment of the people of Kenya to attain a number of aspirations. One of them is statement number 6 of the preamble, which states as follows: recognizing the aspirations of all Kenyans for a government based on essential values of human rights, equality, freedom, democracy, social justice, and the rule of law. The Constitution under Article 2, Sub-Article 1 proclaims itself as the supreme law of the land that binds all persons and all state organs. Article 3 obligates every person to respect, uphold, and defend the Constitution. It matters not whether they are mighty or low. The Constitution further proceeds to specify the national values and principles of national governance that bind all state organs and all persons whenever they make and implement public policy decisions, enact laws, and interpret. Among those values and principles are that contained in Article 10(2)(b), which as human rights, the rule of law, among others, whereas Article 10(2)(c) as the principle of accountability. In matters of national security, Article 238 provides that the principles we shall apply and include the following: that national security is subject to the authority of the Constitution, and the national security shall be pursued in compliance with the law and with utmost respect for the rule of law, democracy, human rights, and fundamental freedoms. The rule of law principle is thus a common right that the Constitution every demands in almost every function to ensure that every person is held accountable to the law. It ensures the equality of all before the law, and it prevents arbitrariness. The task of the court is to ensure there is a fair balance by applying the law when disputes arise either between the state and its citizens, or between citizens themselves, or between state organs or agencies. Neither a state organ or its officers or individual is above the reach of the law, as the Constitution in Article 2 Sub-Article 1 declares. The power of the court to adjudicate disputes according to the law is a delegation by the people pursuant to Article 159, which states that judicial authority is derived from the people and vested in and shall be exercised by courts and tribunals established by under the Constitution. The power is exercised subject only to the Constitution and the law, and is not subject to the control or direction of any person or authority by Article 16. The following excerpt from the South African Constitutional Court in the case of Secretary of Judicial Commission of Inquiry into allegations of state capture, corruption, and fraud in public sector, including organs of state, Zuma and others, sums up the position of court orders in a constitutional democracy. The court held, orders and decisions issued by the court bind all persons to whom and organs of state to which they apply, and no person or organ of the state may interfere in any manner with the function of the courts. It follows from this that disobedience towards court orders or decisions risks rendering our courts impotent and judicial authority a mere mockery. The effectiveness of court orders or decisions is substantially determined by assurance that they will be enforced by all and sundry, including organs of state. In doing so, courts are not only giving effect to the rights of the successful litigant, but also, and more importantly, by acting as guardians of the Constitution, asserting their authority in public interest. End of quote. In the same application, Dr. Fred Matiang'i, the Cabinet Secretary, Minister of Interior and Coordination of National Government, versus Miguna Miguna and 4 others, the Court of Appeal affirming the power to punish for contempt held as follows: when courts issue orders, they do so not as suggestions or pleas to the persons at whom they are directed. Court orders issued ex cathedra are compulsory, peremptory, and expressly binding. It is not for any party, be high or low, weak or mighty, and quite regardless of his status or standing in the society, to decide whether or not to obey, to choose which to obey and which to ignore, or to negotiate the manner of his compliance. This court, as must all courts, will deal firmly and decisively with any party who delays to disobey court orders, and will do so only to preserve its own authority and the dignity, but most to ensure and demonstrate that the constitutional ethics of equality under the law and the upholding of the rule of law are not mere platitudes but present realities. End of quote. The court entered a finding of guilty. This court entered a finding of guilty on the 9th of September 2024 after all efforts afforded to the contender to find the content were ignored. This was to ensure its authority and dignity, which it is exercised on behalf of the public, does not get annihilated, leading to a situation of impunity and anarchy. The Supreme Court, in Gidiga and 5 others versus Jericho Tea Factory Company Limited, acknowledged that courts have inherent power to punish for contempt, to vindicate their authority, besides pinpointing the source of authority of Kenyan courts, to punish for contempt after declaration of unconstitutionality of the content of the Act. 2016. The court stated, and I quote, "Courts possess the inherent power to enforce compliance with their lawful orders through sanctions imposed through contempt of court. We note that the Contempt of Court Act, having been declared unconstitutional in Kenya, Human Rights Commission versus Attorney General and another 2018 EKLR on November 9, 2018, the instructive provision remains Section 5, subsection 1 of the Judicature Act, which grants the High Court and the Court of Appeal the power to punish for contempt. It provides the High Court and the Court of Appeal shall have the same power to punish for contempt of court as for the time being possessed by the High Court of Justice in England, and that power shall extend to upholding the authority and the dignity of subordinate courts." End of quote. Today, this court is required to pass sentence for contempt of court. The principles to be considered in determining an effective sentence in a contempt of court matter were considered by the South African Constitutional Court in Jacob Zuma case, where the court discussed the coercive versus punitive conduct and explained the difference between the two approaches as follows. There is a distinction between coercive and punitive orders, which differences are marked and important. A coercive order gives the respondent the opportunity to avoid imprisonment by complying with the original order and desisting from the offensive conduct. Such an order is made primarily to ensure the effectiveness of the original order by bringing about compliance. A final characteristic is that it only incidentally vindicates the authority of the court that has to be disobeyed. Conversely, the following are the characteristics of a punitive order. A sentence of imprisonment cannot be avoided by any action on the part of the respondent to comply with the original order. The sentence is unsuspended. It is related both to the seriousness of the default and the constitutional amendment appeal. We inform the court that the orders made on 29th of August 2024 were duly served as respondents by the affidavit of service. However, there was neither appearance by the writing of the respondents or responses to the habeas corpus application. There had been no compliance with the orders prior. That necessitated the court to grant an order in which it directed that pending the institution of the changes, if any, the court now directs the unconditional release of the second four petitioners by the first respondent. Number two, that physical service of the order be effected by close of business that day. And number three, that summons be issued to the first respondent to appear in court on the next motion to explain why the habeas corpus issued by the court were not complied with. The matter was fixed for the 9th of September 2024. On the morning of the 9th of September 2024, the Attorney General, the DPP, and the Director of Public and the Director of Intelligence Service, the Inspector General of Police, and the Director of Criminal Investigation appear in due counsel. None of them are required to respond to the application, and the orders of the 29th of August are not being complied with. The Inspector General of Police, who the court and summoned, did not turn up earlier. The court postponed the matter to 3 p.m. office for attendance of the Inspector General to explain why the habeas corpus orders were untrue. The afternoon came and passed. The Inspector General of Police did not attend. The court was informed that he was out of office on official business, with the nature of business being revealed to be a workshop he was attending in Mombasa on budgeting that particular morning. In the afternoon, the court was told that he was engaged in security operational duties in court operation. That matter was rescheduled to 5th of September 2024 at 10 a.m. as the court was keen to establish why the habeas corpus orders would not be executed in respect to the production before the court or the release of the second and fourth petitioners. Ms. Mondugu appearing for the Inspector General explained as follows, when pressed to explain the apparent persistent disregard of the court summons by the Inspector General of Police. The Inspector General of Police has not said he is not coming. He is requesting for another date because it is our position that the second and fourth petitioners are not with the police. The Inspector General of Police is requesting another date to appear because we are brought his officers with the claim. The Inspector General is requesting another date to appear in court, and after holding some brief constitution, Ms. Mondi said the Inspector General of Police will come on Monday 9th of September 2024. The officers of the Inspector General of Police are here and have confirmed his availability on Monday considering his work and duties. End of quote. The court, after this brief session, fixed the matter to 3 p.m. on the same day. Despite the court convening, the Inspector General did not show up. The court finally and luckily agreed to give the final opportunity to the Inspector General of Police to attend court, coinciding with the date that counsel for the Inspector General to be present is available. This was after she had made some brief consultation. The date was Monday, the 9th of September 2024. On that day, the court distressingly wrote, and I quote, "The stream of reasons and excuses by the Inspector General of Police are definitely bound to run out. To proceed at this juncture and estimate a finding of contempt of court may be seen as premature in a grave matter of contempt of court which is a form of criminal sanction being an offense against the administration of justice. Our constitution requires a high threshold of criminal matters. Reluctantly, the reasons for non-attendance bail must be considered. It is thus necessary that I postpone these proceedings to Monday, the 9th of September 2024. The Inspector General, having earlier indicated his availability on this particular day, should have no further excuse but to comply and attend the court physically at 10 a.m. so that the court can put this matter to an end. Due to the persistent non-compliance with both the court summons as well as failure to comply with the orders of 29th of August 2024, the court opined that it was a case of contemptuous conduct that the Inspector General needed to find even as he said the date for the 9th of September 2024. That date came and passed through. The Inspector General did not turn up, but he made last-minute attempt and sent his Deputy Inspector General in charge of Kenya Police to appear on his behalf. The court rejected the arraignment, noting that the open defiance of the court summons had metamorphosed to contemptuous conduct, and it was not a personal matter that and to be directly and specifically addressed to the person summoned. Following the failure to attend court or comply with the order of 29th of August 2023, the court entered a filing of guilty for contempt of court against the acting Inspector General of Police on the 9th of September 2024 and defined the sentence to Friday, the 13th of September 2024. The sentence. As finds it desirable to impose this sentence as a coercive order as opposed to a punitive order. In that regard, Mr. Masengeli may avoid serving this sentence, and therefore, in that regard, the court shall suspend this sentence for 7 days only. The acting Inspector General of Police can redeem himself and comply by availing himself before this court in person to answer to the issues he has been avoiding in the fall. The sentence shall automatically become effective.
So this order.
On the road side of Kenya. On both sides of Kenya.
The local side gets precedence with Miller.
On the road side, my lord, we just want to say thank you. Mr. Allen here. Mr. More about. On the road society of Kenya, my lord, we thank you for the bold ruling. We also are cognizant of the second, third, and fourth petition. Mr. God, Daddy, Jamil Longton, and Aslam Longton. They are still permanent presidents. There is a duty, my lord, on the first defendant the first respondent to uphold, administer, and defend the Constitution and any abrogation of that duty transfers an obligation to invoke the supremacy of the people of Kenya Lord, when we come to the issue of stay, it is an equitable remedy to those who come to the court.
Has it been made?
It has not been made. I do not think I will have an opportunity to address you that because my senior President Harvey. From the Law Society of Kenya, we are still very concerned about the whereabouts of the second, third, and fourth petition. And even as we embrace your ruling, Lord, we pray that court makes a focus in the application as well as the petition, so as to get to the bottom on the safety, the whereabouts, and the personal presentation of the petitions before the court. Lord, I want to rest there and thank the court obviously for giving me. Thank you so much. May I proceed?
Yes, go ahead.
My Lord, prior to the reading of the sentence, Mr. Vita and I tried to address the court on a procedural issue but were not given that opportunity. And the issue at hand, my Lord, is the issue of mitigation prior to sentencing. My Lord, now that that procedural step has been denied to the first respondent, we're now applying that our application be heard this afternoon or latest by tomorrow, bearing in mind that you have suspended the sentence for 7 days. Or latest, sorry, Monday. Today or latest Monday. My Lord, any date after 7 days for our application for hearing would be flying in the
adjustment. It will make sense if the applicant sought leave and if leave was granted to amend prayer 3 in that application. Prayer 3 sought to suspend the sentence pending the hearing of the application. We don't need to amend it to align it with the ruling that has been given by the Honorable Court. So we seek leave, my Lord, to that effect. Number 2, which is a housekeeping issue, it would make sense, my Lord, that as we set the application, today's application for hearing, we hear it together with the petitioner's application that has been pending. I say that, my Lord, because it not only works for the LSK, Mr. President, it also works for the first respondent who has been required by this Honorable Court to give an explanation. And that explanation will have the purpose and effect of answering the application dated 22nd August 2024 by the Law Sergeant Kenya. In terms of final directions, we will pray that on our application, we serve our written submissions by end of day tomorrow, by Monday. We do have the draft form, but we could serve, we could file and serve Monday. On the close of business today, let's be ready. We file our written submissions on the application and serve by close of business today. And with the permission of the court, we take directions on the LSTP application so we can respond to both applications. So maybe I join my learned senior on a priority hearing received within the 7-day window.
Mr. Lord, I support what you're saying because there are two pending applications now. I'm praying for the court to give directions on those two pending applications. Because my Lord, we realize that the sentencing does not bring a closure to the petition. And in terms of priority, my Lord, I believe the application that the first respondent or the signature should be given the priority in terms of the directions to the issue. Yes, my Lord, and I also wish to be on record, my Lord. I was kindly requesting the court to be on record that I sought to bring to the attention of the court that there is a constitutional requirement for a party to mitigate before sentencing, as set out by the Supreme Court in the decision of Francis versus Republic, EKLR 2017. Thank you. Francis Muratitu and Anapti versus Republic 2017 EKLR. Thank you.
My Lord, it's been a heavy day. I don't think we need to burden ourselves with many more complex issues. We can retreat, give directions in the hearing of the application by the first respondent. I think the only prudent course would be for us to give sufficient time to reply to it. A day or two will not be good time. We could have 7 days to a substantive reply. Lord, to give us a mentioned day where we can come and have that application given the directions. We ask for 7 days.
My Lord, in addition to that, we are kindly requesting the court, please omit that for the petitioners. We are kindly requesting the court that our application be had separately from theirs.
Before that, I'd like to check. My name is Ramadan Abubakar. There was a prayer that was made on the issue to amend the application, where they attempted to amend the same order. It is our view that if indeed they intend to amend, perhaps they can serve us with the amended application by close of business today. Then we can put in our response to the same within the same 7 days. So we are opposed to the oral amendments.
Well, I think we are all agreeable. At the very minimum, the court of directed that within 7 days, the first respondent will appear. We will comply. So in between, we can take whatever directions the court wants to fashion. We thought some of those proposals worked for the first petitioner.
So are you able to amend the application?
We are happy to amend by close of business today. We are happy to file our written submissions. It's up to us. And we are happy to comply with the court directions. Whichever direction the court gives in respect to the LST application, they want to delay it, that's up to them.
that